Exohausen in Turkish is dingil actually. It holds the whole system and pushes the power from the engine to the wheels. So it's one of the essential parts of the trucks and also all the automotive. Of course, producing such an important product for the vehicles, we have a huge R&D department and working together with lots of engineers. And every day they have a new idea. Every day they have a new invention, because in this world, right now we are dealing with electronic vehicles as well. Mostly we see them in our automotive, our cars, but also we do have electronic vehicles right now for the trucks as well. Therefore, every day they are producing new ideas and inventing new machines. So whenever they have a new invention, they come to our legal department. And you know what I do? I just want to say the last thing that I'm going to say in this presentation right now, that I call my patent attorney at that moment. So why I call my patent attorney? Because this process, excuse my language, is a real pain in the ass process. Now, of course, I have a small presentation and we will go into the details of prior art search and also obvious and the differences between obvious and non-obvious. But at the end, I think we all come to the same conclusion. So, I will have 3 sections. At first section, I will explain a little bit about what is prior art and the importance and the importance of prior art and the steps of prior art research. The second one is the obvious and non-obvious differences. And of course, third one is the strategies for a successful patent application. So coming to the first question, what is prior art? Prior art encompasses all publicly available information that could relate to an invention before a given date. This includes patents, published patent applications, academic papers, articles, public demonstrations, and even public discussions. Essentially, prior art represents this existing body of knowledge that forms the backdrop against which a new invention is evaluated. The role of prior art is to provide a comprehensive context to determine whether an invention is genuinely novel and inventive. So, secrets of uncovering relevant prior art. First of all, defining the scope and keywords accurately is essential. Understanding the invention. Truly comprehend the invention's key components, functions, and intended use. Developing a list of keywords is also another essential thing. To create a comprehensive list of keywords and synonyms and describe the invention include technical terms, industry jargon, and variations in terminology. Using multiple databases, using this patent databases like WIPO, EPO, European Patent Office, ESPACANATE, Google Patents, and American US Patent Office database is essential in this session. And also, using non-patent literature is essential too. Exploring scientific journals, technical papers, industry publications, conference proceedings, and online repositories like IEEE Explore, and Science Direct, and PubMed. Also, having advanced search techniques, using different techniques like Boolean operators, like use and or not. Wildcards and truncations is essential, like truncation symbols to search for variations of a root of a word. And proximity search, using proximity operators to find documents where keywords appear within a certain number of words of each other. Classifying and categorizing. Utilizing patent classification systems such as the International Patent Classification, Cooperative Patent Classifications, and United States Patent Classification to locate relevant patents with a specific technologies category. And also industry-specific classifications, considering the industry-specific classifications and terminologies that may help to narrow down the search. Examining cited references and backward citations. Reviewing the references cited in relevant patents and publications. These often point to prior art that the authors or inventors considered relevant. Also backward citations can lead to newer developments and related inventions as well. Utilizing professional search tools and services. In this case, considering subscribing to commercial patent databases like Durban's World Patents Index, LexisNexis, Total Patent, and Castle for more comprehensive search capabilities. Engaging professionals or patent attorneys who specialize in conducting thorough and strategic prior art search also help. Of course, AI is everywhere. Leveraging AI and machine learning will definitely help in this prior art research process. Of course, we do use AI and engines and machines everywhere, but manual review is still essential, which ensures accuracy with manual review. Despite the efficiency of automated tools, and manual review of the most relevant documents is essential to ensure accuracy and relevance. And also consulting experts in this case helps as well. And of course, everything is not in English. There are many inventors all around the world. In Turkey, we do also apply for the Turkish Patent Institute, and we do use Turkish. Also in other countries like India and other countries, they do use their native language. So conducting a research not only in English but also in different languages helps to understand the prior art search better. Documenting and analyzing all the findings. As I said at the beginning of my speech, this prior art search is a really long process, and maintaining records and keeping details during all the search is essential. Also, critically analyzing the relevance and implications of each piece of prior art. Determine how it relates to the invention's novelty and intensive step. And we mustn't forget that this process is an iterative process. So you once again start from the scratch, you make rounds, and it doesn't end in the first research. So based on initial findings, refining and expanding your search criteria, prior art search is often an iterative process that involves multiple rounds of searching and analysis. In a nutshell, uncovering relevant prior art is a sophisticated process that requires a combination of strategic planning, advanced search techniques, and expert analysis. By employing these secrets, inventors and patent professionals can conduct raw and effective prior art search, increasing the likelihood of identifying all the pertinent references and successfully navigating the patent application process. So coming to the next question, how to differentiate between obvious and non-obvious inventions in the eyes of the patent office? Because whenever your colleague from R&D department comes to you, I have a new invention, this is different than the others. You have to prove that it's non-obvious, right? But it's not that easy, because sometimes they are just embedding a small bold in it, and they said, yeah, that's non-obvious because I made a difference, and it's not easy to explain it. So let's have a look at what is the obvious and non-obvious differences. So do you remember from law school, the Roman law, we have that wording bona pater familias. In Turkey, we do start law schools with Roman law at first grade, and the first thing that they told us is the bona pater familias. You have to think like a bona pater familias in every case. Here, for differentiating the obvious and non-obvious, we have the posita standard. This is quite similar to bona pater familias. What is posita is short for person having ordinary skill in the art. The determination of obviousness is made from the perspective of a person having an ordinary skill in the art, posita. At the time that the invention was made, this hypothetical person possesses average knowledge and skills in the relevant field, but is not an innovator or genius. So this is quite similar to our bona pater familias version, but we do use this differentiating between the obvious and non-obvious. The second one is Graham factors. This Graham factors coming from Supreme Court case of the US, I don't remember the year, but in that Supreme Court case, they have set 4 rules, so 4 basic rules. Scope and content of the prior art, examining all relevant prior art references, differences between the prior art and the claims at issue. In this, identifying the differences between the prior art and the claimed invention is important. Level of ordinary skill in the pertinent art, determining the level of skill in the relevant field. And also, objective indicia and non-obviousness, or let's call it secondary considerations, considering the evidence such as commercial success, long felt but unsolved needs, failure of others, and also unexpected results. The second differentiation model might be the teaching, suggestion, and motivation test. What is this TSM test? TSM test assesses whether there was some teaching, suggestion, or motivation in the prior art that would have led a posita to combine existing references to achieve the claimed invention. If the prior art provides a clear rationale to combine elements as claimed, the invention may be deemed obvious. So, combining prior art references. Analogous art. When evaluating the combination of prior art references, analogous art, the references must be analogous, meaning they are from the same field of endeavor or reasonably pertinent to the problem faced by the inventor. Predictable results. If the combination of prior art yields predictable results, the invention is more likely to be considered obvious. Unexpected results. Non-obviousness is often supported by showing that the invention yields unexpected or superior results compared to what was predictable from prior art combinations. Coming to objective evidence of non-obviousness. So, commercial success. If the invention has achieved significant commercial success, it may suggest that the invention was not obvious. If its it's a long-felt but unsolved need. If the invention solves a problem that has long been recognized but not solved by others, it supports non-obviousness. If the evidence that others have tried and failed to solve the problem, in the same way can support the non-obviousness of the invention. If competitors have copied the invention, it may indicate that the invention is not obvious as well. And also, if experts were initially skeptical about feasibility of the invention, it may suggest non-obviousness as well. So, we may also try a flexible approach to understand between whether it's obvious or non-obvious. If an invention is merely an obvious solution, to try among a finite number of identified, predictable solutions, it may be considered obvious. Factors such as market demand and known design incentives can be considered when determining obviousness as well. So, there are also some practical steps for differentiation. Conducting comprehensive prior art search, so ensuring a thorough search of all relevant prior art to understand the current state of knowledge in the field. So every time we come back to prior art search as well, which was the essential part of this patent application. Also keeping detailed records of the development process, highlighting the inventive steps and challenging overcome helps our process as well. Clearly articulate any unexpected results or advantages of the invention over prior art. Also gathering and presenting objective evidence of non-obviousness, such as commercial success, industry praise, or solving long-standing problems. Also, carefully analyzing whether the combinations of prior art would yield predictable results and whether there was a motivation to combine such references. So, differentiating between obvious and non-obvious inventions involves a careful and multifaceted analysis by applying established legal standards and tests, such as the Graham factors, TSM test, and considering secondary evidence. Patent offices aim to ensure that patents are awarded only for truly inventive contributions. Understanding this criteria helps inventors and patent practitioners better prepare their applications to demonstrate the non-obvious nature of their inventions. Coming to our third and the last question, what are the strategies for strengthening your patent application based on prior art analysis? In order to have a strong patent application, there are a couple of things that you should consider at first hand. Of course, we are starting once again with a comprehensive search, prior art search. So, performing an exhaustive search using multiple databases like Google Patents, MIPO, EPO, and USPTO to uncover all relevant prior art is essential. Conducting broad and narrow search, using broad and narrow search terms to capture a wide range of prior art that might be relevant to your invention. Updating your search regularly, not doing for once, but coming back and back again and conducting research to help your patent application more reliable. Analyzing and categorizing prior art is also essential. Carefully assess the relevance of each piece of prior art to your invention. Look for gaps or deficiencies in the prior art that your invention addresses. This can help to highlight the novelty and inventive step in your patent application. Refining and clarifying your claims. Draft claims that are specific and precise avoid overly broad or vague language that could overlap with prior art. Use dependent claims to narrow down the scope and cover various embodiments of your invention. This can provide fallback positions during examination. Emphasizing the unique and non-obvious features of your invention of the claims. Comprehensive description is also essential, including a detailed description of invention, explaining how it works, its components, and its advantages over prior art. Describing multiple embodiments and variations of your invention to cover different possible implementations and protect against design rounds. Using figures, diagrams, and flow charts to illustrate the invention clearly and support the written description. Addressing potential objections preemptively is important. Anticipate potential objections or rejections based on prior art and address them proactively in your application, and include detailed arguments and explanations to support novelty and non-obviousness of your invention. Consider filing a provisional application as well. And actively monitor and respond to examiner actions. By strategically analyzing prior art and meticulously preparing your patent application, you can significantly strengthen your case for patentability. This involves thorough prior art search, careful claim drafting, detailed descriptions, and proactive addressing of potential issues. Leveraging professional expertise and providing robust evidence. Evidence. Where was I? I just lost my place. Leveraging professional expertise and providing robust evidence of the invention's novelty and non-obviousness can further enhance the likelihood of securing a strong and enforceable patent. And that was my last sentence. So in case of an invention, don't suffer, just call your patent lawyer. Thank you.